All right, we'll go ahead and get started. My name's Chris Berry, certified LO attorney, certified financial planner with Castle Wealth Group. And we do these weekly wisdom webinars where we answer questions that are submitted either ahead of time or while we're live on the Zoom. I always like to start with a positive focus, just something positive that happened over the last week. Um, my daughter is 12, Madison, and we started watching like wrestling, like WWE, a little bit. So we actually they came to Detroit. So we went to wrestling Monday night, Little Caesars, and kind of watched that together. It was kind of fun. Um, Kind of silly, but she had a good time, and so it was a good time. All right. So, like I said, we always just answer any legal, financial, or tax planning questions that are submitted. So if you do have a question or something on your mind, feel free to put it in the Q&A. Otherwise, I did have one question that was submitted ahead of time. Let me pull that up real quick. All right. So the question is, how early should someone start considering legal documents like powers of attorney or advanced directives? So really, the question is like, when do we start thinking about estate planning? And this is something we talk about in our workshops, and we do workshops usually a couple times a month at one of our different locations. But understand kind of we see a life cycle of estate planning. I was even meeting with some clients in their early 50s, or they are 50 today, and they have some young kids. So we're talking about this life cycle of estate planning. So understand, once someone turns 18, legally they're adults. And so that's kind of the starting point is for a lot of our clients who have adult age kids who are over the age of 18, at the very least, we're getting like financial and medical powers of attorney put together, naming the parents to be able to serve that role. Because understand, once someone turns 18, even if you're paying for their insurance, legally they're adults. And so if they're injured, they're in a car accident, unless they have a medical power of attorney or HIPAA release, you wouldn't be able to talk to the doctors or anything. So I would say estate planning really starts at age 18. Understand, like college age kids, they don't care. So it's really like our clients, the parents who are saying, hey, you need to get these documents in place so that we can make decisions for you if something were to happen. So that'd be the starting point is once someone turns 18, at the very least, they should have a financial medical power of attorney, maybe naming a parent to be able to make those decisions. And then kind of the next step in terms of kind of looking at that life journey would be having a child. So getting married and having a child. Then we start looking at a will and a trust. The will would appoint a guardian. So God forbid something happens to you as a parent, who's going to serve as that substitute parent. And then with the trust, like who's going to manage the money for the benefit of the kids? Like my kids are 12 and 14. God forbid my wife and I get hit by a bus. We don't want the money going outright to a 12 and 14-year-old. So we have a trust set up to manage the money for the benefit of the kids. So that would be really one of the first big life events is getting married and having a child or having multiple children. And a lot of times I sit down with the family, they did an estate plan when they had the first child, but now they have two others and they haven't updated the estate plan. So we want to make sure all the kids are included in that estate plan. And then probably the next big uh, kind of change would be in terms of that life journey would be, okay, now the kids are older, they're getting married, the kids are having kids, you're getting around retirement age. And so now a lot of times, a lot of our clients switch from just like a basic trust plan that says it just goes all right to the kids once they reach a certain age, but now they're building in what we call legacy provisions. So now whatever the kids inherit from you would be protected from things like divorces, creditors, bankruptcies, and if they were to pass away, the money doesn't go to a spouse who might remarry, but stays in the bloodline. So it would flow down to your grandkids. And then if there aren't any grandkids, would go to the surviving child. Um, so usually that's when clients get more near retirement age and they see who the kids are marrying. Not to say that we don't like the in-laws, but We jokingly call them the outlaws. So we want to keep the money in the family. So that's where maybe we upgrade from just a basic trust plan to what we call a legacy plan to protect that legacy. And then as we continue to age, a lot of times my clients see like what's going on with their parents and the long-term care costs, and now they want to protect themselves from like that nursing home or Medicaid spend down, which might be ten to $15,000 a month. And so we upgrade from like a legacy plan to an asset protection plan to protect against that nursing home or Medicaid spend down. And so, yeah, really I'd say there's kind of like four stages. So the first stage is once someone turns 18, they need to have powers of attorney in place. At least naming the parents to be able to make decisions. God forbid there's an accident or injury or something like that. Because again, once someone turns 18, legally they're adults. So that'd be the first step. And then the second step would be, all right, now we're getting married, we're having kids, we want to put together at least a base trust plan. Okay. And then 20, 30, 40 years go on. Now we're getting near retirement age. We're seeing who the kids are marrying. The kids are having kids of their own. And now we're looking at a legacy plan. And then typically around like 60 to 70, then we start getting concerned about long-term care costs and we're looking at putting together an asset protection plan. So again, like an estate plan, it's not a one and done type thing. The estate plan is something that should be changing based on like where we are in terms of the life journey. But yeah, I would say at age 18, that's when we need to have powers of attorney. Then we get married, we have kids, we need to have a base plan. We see our kids are getting older, they're getting married, then we upgrade to a legacy plan. We're starting to age. Now we need to think about planning for long-term care cost. So that's kind of the journey of that life journey where we need to look at updating the estate plan based on where people are at. And that's where, whenever we're sitting down with clients, we're always figuring out what their goals are, what they're trying to accomplish, and then picking the right tools. So even today, I sat down with a couple, both of them are in their 50 or 50. They have two young kids. One's 18, or no, one was like 15, one was 20. So we had to think about guardianship issues. They weren't super concerned about long-term care costs yet. So we're looking at more of the base versus the legacy plan. And then understand that for that 20-year-old kid that they have, like we need to put together powers of attorney for them. So yeah, so hopefully that's helpful. I'm kind of outlining the life journey as it relates to estate planning and understanding that yeah, at age 18, we need to start thinking about it. Again, the 18-year-old isn't going to think about it. So it's usually the parent that says, hey, like we need to get this done. And then the kid gets older, they get married, they have kids. Now we need to think about a basic estate plan. Another 20 years go down the line. Now the kids are getting married. Maybe they're having kids. We're looking at that legacy plan to make sure any inheritance is staying in the family. And then as we continue to age, maybe we're concerned about long-term care costs. And now we're looking at some asset protection or long-term care planning. So yeah, so hopefully that's helpful. And that's really the only question I have submitted this week. So with that, thank you. If you do have any other questions, feel free to email them over and we can address them next week.